House Judiciary Committee will come to order. Would the clerk please take attendance?
Chair Runstead.
Here.
Representatives Tice.
Here.
Howrlack.
Here.
Cole.
Here.
Hornberger.
Here.
LaFave.
Here.
Greimel.
Here.
Robinson. Guerra.
Here.
Sowerby.
Here.
Mr. Chair, a quorum of the committee is present.
Thank you. And first, we're going to take up Senate Bill 333, and we have Nick Capone and Tom Clement of Scale, the State Supreme Court Administrative Office, to testify. Go ahead whenever you're ready.
Thank you, Chairman Runstead, members of the committee. I'm Senator Jones' legislative director. Unfortunately, he is stuck over in Senate Judiciary. But we appreciate you taking up Senate Bill 333 for a hearing today. This bill is essentially to clarify what types of cases should be allowed into the business court system. And with that, I'd like to turn it over to Tom Clement with the State Supreme Court Administrative Office.
Thank you, Mr. Chairman. Good afternoon. My name is Tom Clement. I'm General Counsel to the Michigan Supreme Court. The Senate Bill 333, which we support, is a fairly straightforward jurisdictional bill. It's commonly known as the business court statute, and what we're trying to clarify is what types of cases need to be heard in the business court. Apologies for Judges Jim Alexander and Judge Chris Yates, who are the primary drivers of this legislation, but I can unequivocally convey to you that they strongly support this bill, and they're just unavailable with their dockets today. I would also indicate that this bill has the support of business court judges throughout the state. So as I indicated, the primary purpose is to clean up and clarify outstanding jurisdictional issues, and primarily this bill does three main things. The first is to expand the jurisdiction of the court to matters seeking equitable and declaratory relief rather than just money damages. And all I can convey to the committee is I think when the statute was originally written, it was just an oversight, because clearly in business court disputes, there's going to be declaratory and equitable relief is going to be sought on a fairly regular basis, so it's very appropriate that those matters be within the jurisdiction of the business court. The second is clarifying the definition of business or commercial dispute and more precisely defining the word member. So just to be specific about it, it's outlining specifically who are the appropriate parties that are to be before the business court and having their matter adjudicated before the business court. So it's supposed to be businesses, and the problems that we're running into is we use the word member in the statute, and so what we were finding is that quote-unquote members, for example, of a credit union were being sued and hauled into business court, which is obviously inappropriate. So we want to clarify that language and that wording within that provision of the statute. And then third, we are working to exclude matters involving residential property, so that would be essentially foreclosure matters. The reason we're doing that is foreclosure matters are fairly straightforward and don't need the particularized knowledge that the business court judge may have. And we also want to treat all residential property cases the same regardless of ownership. So if I own it, or if an LLC that I own owns it, we want that to be heard in the same court, not one going to business court and one going to general circuit court. So again, very technical, straightforward fixes that just get even further drive us in a direction of having the business court have jurisdiction over true and actual business disputes. So that's what we're after, and that's what we feel this bill accomplishes. And I can answer any questions that you may have.
Thank you. Any questions from the committee? Yes, Representative Greimel.
Yeah, thank you for being here and for your testimony. A couple of questions. What happens if some of the adverse parties are members or otherwise owners of a business entity, but some folks are also party to the suit who don't fit that bill? Would the case, that is to say, let's say on one side you've got a defendant who's a business entity. Among the plaintiffs, you have some who are members or former members of that business entity, but you also have some folks who are not members of that LLC. Would that fall into the business court realm or not?
I don't believe that it would. I don't know that for certain, but I can get you that answer, but I believe it would kick over to general circuit jurisdiction.
Okay. And then the other question I have is, it sounds like in some ways this will more narrowly tailor who can bring actions in business court, although it sounds like in some ways it might expand who can bring, or at least clarify that some entities, like members of an LLC, can bring a case in business court. Do you anticipate that the net effect of this will be more or less cases in business court?
So Chris Yates, Kent County Circuit Court, testified in Senate Judiciary that it was going to be docket neutral.
Okay.
I steal his answer.
Fair enough. All right, thank you.
Any other questions from the committee? Apparently there is not. Well, thank you very much for your testimony.
Thank you.
Next, we will be moving on to take up House Bills 4416, 4417, 4418, and 4419. And our first up, I would like to call up Representative Kurt Vanderwall, who apparently has a letter from his sheriff.
Thank you, Mr. Chair, and thank you, committee, for allowing me to read a letter from Sheriff Kim Cole from Mason County. It says, Mr. Vanderwall, I write this letter in support of upcoming legislation as it relates to constitutional carry of a pistol for lawful, responsible Michigan residents. On December 19, 2012, I raised my right hand and was sworn in as the new sheriff of Mason County, Michigan. During the ceremony, I swore to uphold the Constitution of the United States and the Constitution of the state of Michigan. And that I would do so to the best of my ability, so help me God. As elected official, I am obligated to uphold my oath on all matters related to the Constitution, and highlighted all. I am not a fan of those who choose to protest against law enforcement. I do, however, support their right to peacefully do so. Why? Because, as you know, it is protected on the First Amendment, just as the Second Amendment protects lawful citizens the right to keep and bear arms. I get the concerns, I really do. I had a friend murdered by gunfire, a friend who was a police officer, murdered only because of what the uniform he was wearing stood for, freedom. I sat in the back of the ambulance holding the dying friend's hand and saw the devastation that can be caused by a firearm in the hands of a criminal. But it is wrong to use examples like this as reasons to place honest, responsible folks in a box and require them to fill out forms and pay fees for something our forefathers promised us as American citizens, and others like my friend and scores of others have died for. Criminal predators don't care about the laws, the Constitution, permits, or others' rights. All they want to do is prey upon the unsuspecting. My friend was gunned down by a criminal who held no permit, probably had never heard of the Constitution, and cared not only about others' rights, he simply did not want to go to jail for breaking the law. You can't stop these tragedies from occurring no matter how strict you make the laws. Guns and keep guns out of hands of bad people. It's just not a reality. Instead, target those who violate the law and endanger others by enacting strict and severe penalties for felons who possess unlawful firearms or use firearms to victimize others. Self-defense situations are difficult, if not impossible to predict, and law enforcement can't always be there. It is because of this and what I already laid out that make me feel lawful, responsible, and qualified Michigan residents should be afforded their right under the Second Amendment to keep and bear arms so that they can have the chance, if needed, to protect themselves. Respectively, Kim C. Cole, Sheriff, Mason County, Michigan. Thank you.
Thank you, Representative Vanderwall. And next, I would like to call up Blaine Coops, CEO. Oh, I'm sorry. Go. Hold up 1 second, Representative. We had a question for you from Representative Greimel.
Representative, I just have one question. Is the sheriff speaking on behalf of only himself, or is he speaking on behalf of the Michigan Sheriff's Association?
He is speaking on behalf of himself.
Okay, thank you.
Thank you again. And next, we have to answer Representative Grimal's question, the Michigan Sheriff's Association, and this is Blaine Coops, CEO, and Sheriff Matt Saxton. Please come up to the table when you're able, and proceed whenever you're ready.
Good afternoon, Mr. Chair and committee members. Thanks for having us here today. I am Blaine Copes. I am the Executive Director for the Michigan Sheriff's Association. Our association represents all 83 sheriffs in the state of Michigan. And we have a rather long history. We've been around for 140 years. So we have the tradition of serving our sheriffs and their constituents for a fair amount of time. With that, I'd like to introduce the Honorable Matt Saxton, the Sheriff from Calhoun County. Your Honor.
Good afternoon, Chair Runstead, Commissioners, or committee members. Thank you for your time today. As Blaine mentioned, I am one of 83 sheriffs that are members of the MSA, and I am here to give testimony today, not unlike that of my friend Sheriff Kim Cole from Mason County, whose letter was just read. There's not one of the 83 sheriffs that do not believe that a member or a citizen in the state of Michigan should forego their Second Amendment right to keep and bear arms. And I don't believe we have laws in the state of Michigan that currently prohibit that. I am here today to speak to the fact that I do have concerns of 4416 through 19, and only on the lack of training that would be required of a person to carry after this law is enacted, and essentially doing away with the need for a CPL to carry concealed in a vehicle. And the other concern is that we today place more and more responsibilities on the men and women that put this uniform on, whether it's brown or blue or green, that serve each one of us as citizens of the state of Michigan, whether it's in the UP or in Southwest Michigan where I provide that service. Those law enforcement officers we require more and more of on a daily basis, and to properly vet a person the way it is done now with a CPL license is done in the office and not on the side of a road or at a front door of a residence. And I think that helps this process, and to require an officer to do that on the side of the road or at the front door when taking a call is additional stress that officer doesn't need to have in performing their duties to serve the citizens of the great state of Michigan.
Thank you. Do we have, we do have questions from the committee. Representative Cole.
Thank you very much, Mr. Chair, and thank you, Sheriff, for being here very much. A couple of things concern me with your testimony a little bit. Number one, we have open carry, which requires no training right now. So I'm curious on your take of what changes with that person's constitutional right when they put a coat on, and what happens with the safety when someone puts a coat on.
Well, to carry concealed in the state of Michigan currently, you need a CPL license to do so. And that vetting of that person is done in an office setting, and that's not done on the side of a road. We do have great difficulties for our officers when there is an open carry situation, and we often get called to those because if a citizen sees a firearm, some citizens are either put off by that or afraid of that, and they call 911. So we get called to investigate that person. If a person is carrying concealed, we don't often get those calls, because if they're truly carrying concealed, the sense of the word, nobody's going to see it. But oftentimes, those officers who are trained to recognize somebody carrying concealed will come across that. And with a CPL and on a traffic stop, they do notify that officer that they have a CPL and they are carrying. So vetting doesn't have to occur in that situation. We can then confirm the CPL, which they have a card, and we can also do that via law enforcement information network.
The other part of your testimony that concerns me a little bit is about this, finding out at the front door of a residence. I don't need a CPL to carry concealed in my home. So,
Did you say finding it out or?
yeah,
finding it
when
out?
you mentioned finding this
I thought
out
you
at the
said
front
finding it out.
door.
Right, if we're called
I
to
mean,
a-
I can, that's potentially making a stretch that I'm gonna need a permit to have a gun in my home.
I
I want to make
don't,
sure that we're clear on, I don't think that's what you meant, but I want to make sure of that.
and I by no ways meant that.
Okay.
But we get called to residents for domestic violence situations. We try and find out information prior to arriving to make it easier to resolve the situation. 911 callers on domestic situations are, one of the questions a dispatcher asks is, are there any firearms in the residence? Oftentimes, we'll run a file valid on the persons involved to see if there's any outstanding warrants. And we can, for officer safety reasons, request the dispatcher to check and see if there is a CPL along in that residence, which would give that officer a little bit more knowledge going to that front door as opposed to change.
I understand the point you're making, but at the same time, a person's either going to be a law-abiding citizen or they're not. And the ones that are not, you're not going to know. Why are we making more hoops and making it harder for our law-abiding citizens to possess and carry a lawfully possessed firearm when the ones that you actually are worried about, they don't follow any of these laws? And how is this going to help you remain safe when you're dealing with people that don't follow the laws in the first place?
You're completely accurate there, sir. We're not asking for any changes. Currently, we have a CPL process in the state of Michigan. We're simply asking to continue that process the way it is now. And I personally, stepping away from MSI side of things, I personally think there's a lot of options we can talk about to greatly enhance the Second Amendment rights of folks here in Michigan. This package of bills, I don't think, does that.
Thank you. Thank you, Mr. Chair.
Next is Representative Howerlick.
Thank you. I was hoping that maybe you could speak a little bit more to your concerns about the after effect of, say these bills go into law and they become the new law of Michigan. On a practical level, how's that going to change things? And could you speak a little more specifically to your concerns?
Let me see if I understand your questions, but if this package of bills goes in to law, how is that going to affect our deputies or officers' day-to-day business?
At least folks who interact with folks who perhaps are carrying weapons, guns in particular, pistols in particular.
Well, to change that, and if they're doing so without having a CPL, if we run across a person carrying a firearm on a traffic stop, the vetting of that subject will have to be done on the side of the road, whether they are legally in possession of that firearm or have committed crimes or are prohibited in some matter, whether it's by state law or federal law, to possess that firearm. That'll have to be done on the side of the road if they don't have a CPL. And I understand this package of bills does not do away with the CPL, but just because it's not done away with it, there are just still going to be folks that choose not to get a CPL for whatever reason. which will have folks that haven't gone through any training, which goes back to our concerns. The training and vetting individuals on the side of the street in a traffic stop, which could potentially, the courts have ruled now that an average traffic stop shouldn't be any longer than 20 minutes. But if we have to vet that person, I could see it taking much longer than that. To vet them, we would have to actually run a criminal history, which to do so, we have to document our reasonings for doing that, and we'll have to justify why we ran that criminal history a year and a half, 2 years down the road when we have our lien audit. So it just adds additional work to the good men and women in law enforcement to serve us each day. And I again, have concerns with putting more on the shoulders of the men and women in law enforcement.
Thank you.
Representative LaFave.
Thank you, Mr. Chairman. My question is, can you give me a number of the elected sheriffs out of the 83 that are in support or against?
Let me put it this way, these items come before our board of directors, and our board of directors votes on this because they represent each district in the state of Michigan. So as far as the number, no, we can't. But I can tell you the board of directors is opposed to this legislation as it's written. Along with that, to go along with what Sheriff Saxon was saying, is the CPL really helps express that traffic stop. If indeed the police officer can say, oh, this person's got a valid CPL, okay, so we're okay. If he can't or she can't do that, it just will take that situation and expand it out to the point where now where a routine traffic stop now gets expanded out to a further investigation. So it's a good thing for the police officer, it's a good thing for the CPL owner. It takes that level of anxiety down dramatically for that traffic stop. And as we all know, our police officers, there's 4,000 fewer in the state of Michigan today than what there were in 2001. So they're under extreme pressure.
Well, and I certainly don't dispute that our law enforcement officers do one heck of a good job, and we put a lot of burdens on them. It's a job, frankly, I would never want to do. You guys do wonderful things. I am a little bit disappointed because I just texted one of my sheriffs, and I've got 3 of them. I have 3 full counties. Ed Oswald said that he's in full support of it. I'm contacting the other 2, and I know one of them personally, I'm sure he's going to say yes as soon as I get back to him. So if I would ask personally in the future if the Sheriff's Association would be able to give me the names of the sheriffs and see where they come down on something, because from what I'm seeing from my district, my sheriffs like the bill.
I report to a board of directors, and that's where I take my director from, and they represent their constituents, their other sheriffs within their districts.
Well, respectfully on this issue, I don't think they're respecting the sheriffs of my district.
Next, we have back to Representative Cole.
Thank you, Mr. Chair, for the follow-up on this. Just wanted to follow up on this vetting on the side of the road issue. And if someone calls you because there's an open carry individual out there, don't you still have to vet them on the side of the road?
Yes, with the open carry situation, we do have. If that open carry individual has a CPL, that process is a lot shorter.
But a lot of the open carry individuals choose to exercise their constitutional right to open carry versus acquire a CPL for a variety of reasons.
Right.
So are you approaching them with the mindset that they're unlawful, or are you approaching them with the mindset that they're a lawful gun owner?
Every situation is different, so it would have to rely upon the information we have at the time of the 911 call, what information we have. So we're using everything possible to ascertain when we're responding to an open carry situation, what's going on. We're seeing it probably less than we did 3-4 years ago, but we still get calls from time to time for the open carry situations. We had, we're probably close to 8,000 CPL holders in Calhoun County. We have not had a major incident involved with a CPL holder in Calhoun County. Again, I go back to, I personally am not against any citizen's Second Amendment right to own and possess a firearm. Just have concerns with this package of bills, and I think there's other options to move forward.
So
with.
8,000 CPLs in Calhoun County. How many legal gun owners that don't have CPLs?
That I don't know.
And how many crimes are committed by legal gun owners in Calhoun County?
I don't have
The
that.
illegal side
I
of
don't
things,
have
which we're
that
all concerned
information in front of me. I do know, because I try and keep track of that, is the number of CPLs. I understand that there were about 2,500 individuals that were denied a CPL this past year because of the vetting that takes place at the application time. Of those, I don't know how many are citizens of Calhoun County. On average, back when we used to have gun boards, we would have probably 2% denied. And oftentimes in Calhoun County, we worked with those individuals as opposed to flat out denying them. We may table their application and help them get in the position where they are if they're able to be a CPL license holder.
But not to rehash that debate, but the sky didn't fall
Sorry
when
to
we
bring
went
it
to
up.
when we went to a shall issue state.
I don't disagree. It did
And-
not,
and-
it did, my concerns, and I told folks in Calhoun County of my concerns when we went to that, where I felt citizens of Calhoun County might take longer to get a CPL than, again, in this process, I think the advantages of having a CPL, and the vetting not on the side of the road, helps all of us stay safer here in the state.
Okay,
of
we have
Michigan.
to keep
Sorry,
moving.
sorry, thank
No
you.
problem. Representative Sowerby.
Thank you, Mr. Chairman, and thank you for your testimony, Sheriff from Calhoun County, and your service you give to the people of Calhoun County. What is your position with the Sheriff's Association?
I am currently a sheriff member of the association, one of 83, as I mentioned initially. I served the past 4 years on the board of directors as the new sheriff representative for the past 4 years, and I'm currently an alternate board member for Southwest Michigan
Okay,
District.
and to your colleague there, you had mentioned the Board of Directors voted unanimously to oppose this bill?
Yes.
And can you name who those Board of Directors are?
Right now, I don't have that with me.
How many are on your Board of Directors?
I think there's 8, no, 5, there's 5, or 6, there's 6 districts.
Can you name, six, okay, so the Board of Directors represent the districts?
Yes, they represent their district. The sheriff from Berrien County, Paul Bailey, Tim Donlin from St. Clair County, who is the president. That's all I can think of right now.
When you are able to find out if you
Oh,
could...
I will. Please
Let
understand.
the committee know who those members are that are on the Board of Directors that voted unanimously against the bill.
Please understand, I started in January.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, and we got to keep moving along, so thank you very much for your testimony.
Thank you.
Thank you for your time.
And I do have a letter from a sheriff in Berry County, Dar Leaf, who was involved with some of the discussions we had looking at making some changes. He was very involved and was going to be here today. Unfortunately, ended up in the hospital yesterday. So he has sent a letter that he asked me to read. And pardon?
I'm sorry to interject. Could I ask one question of the, I know they've left the table, but could I ask one question of the Sheriff's Association?
You make it real quick, just a question.
Yeah, thank you. I apologize. I'm on your website right now, and I just wanted to see if all of these individuals are still on the Board of Directors. Sheriff Pete Wallen from Emmett County, Sheriff Gary Benecki from Sanilac County, Sheriff Paul Bailey from Berrien County, Sheriff Tim Donnellan from St. Clair County, Sheriff Kirk Wakefield from Crawford County, Sheriff Scott Stevenson from Midland County, and Sheriff Mark Villasano from Iron County, which I believe is in Representative LaFave's district. Are those all, oh, that's not actually, that's in Representative Diana's district. Borders your district. Are all those individual names correct?
That is correct.
Okay, thank you.
Thank you. So this, again, is the letter from the Sheriff of Berry County, Darleaf, who was very upset he couldn't be here today. I'm in favor of the constitutional carry bill, which you are hearing today. Back in 1999 and 2000, when the shall issue was a hot topic, many naysayers put unnecessary fear in the public. Prominent people in public offices from 25 shall issue states were saying that there was going to be blood in the streets, or this will turn Michigan into the wild, wild west. Well, we're here in 2017, and none of that has happened. If you look into the wild, wild west, you'll see a 15-year span of the roughest cattle towns in the country with very few problems. The legendary Dodge City between 1870 and 1885 had 15 homicides, with 5 in 1878. Abilene had 7 total in that time frame, while Ellsworth 6, Caldwell 13, and Wichita 4, all in the same 15-year time frame. Those are not bad statistics. Even better than the statistics of Public Act 381 of 2000, none of those fears came true. Just the opposite happened, especially with accidental discharge. In Arizona, you can carry just about any way you want. How many of us take vacations there with their children? Article 1, Section 23 of Michigan's Constitution and Amendment 9 of the U.S. Constitution both read, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, just because it is not listed in the Constitution as a right does not mean it is not your right. Just as getting a tattoo supported by the state of Michigan or the right to defend one's gift of life, these are natural rights that our founders were adamant about us keeping. The people I spoke to said they are tired of the government taking away their rights and then selling them back to us. This is not right, but this is not a right but a privilege, because we are seeking permission to exercise the act. The LGBT community won a huge case involving marriage using the Fifth Amendment, due process, and the 14th Amendment. Equal protection under the law. We have several exemptions to the current CPL law which give more rights to certain groups over others. How is that equal? Article 1, Section 2 is very clear that it is not. When is the Constitution going to do its job? Judges are exempt. They do they train like others are asked to do? I do not hear any lobby group complaining about that. Corrections deputies, retired police, all are exempt groups that have extra rights or privileges. The Memorial Day traffic will not be allowed on the bridge because of fear that a terrorist or mentally ill person will drive into people with the vehicle. This is a new problem that we have in society today. Mental illness is a problem alone. After 12 years as sheriff of Berrien County, no one has given me an answer on how to stop someone from purchasing a gun through lien or NCIC. I'm not worried about the law-abiding citizen. I am worried about how to respond to someone who's known to be mentally ill and stop them before they become a danger to our public. The CPL holder has proven themselves worthy. Let's get rid of some of the laws that make an honest mistake a felony. We all know that the firearms laws are confusing. It's not our citizens it's not fair to our citizens. They have to carry around an attorney just to make sure they don't end up in prison. Thank you for listening. Sheriff of Berry County, Dar Leaf. And next we have on the card here, Bob Stevenson and Tom Mulcher of the Michigan Association of Chiefs of Police. Just approach the table when you're ready and begin.
Thank you, Mr. Chairman, members of the committee. My name is Bob Stevenson. I'm the Executive Director with the Michigan Association of Chiefs of Police. Come here today representing some 1,200 members of our association from the 400 approximate cities in the state of Michigan. I have with me today that will be doing the predominant amount of testifying, Director Todd Muchler. Director Muchler is from Northville Township, and he is a member of the Michigan Association of Chiefs of Police Legislative Committee. That, Director?
Thank you, Mr. Chairman and committee members. As Mr. Stevenson just said, I'm here today on behalf of Michigan Association of Chiefs of Police, and from the MACP position regarding this package of bills, we are not interested in a debate on Second Amendment rights. For us, this is really about public safety, and we don't have to look too far back in some of our constituents and colleagues in the city of Dearborn who is dealing with a very, very dangerous issue and looking for some remediation and assistance legislatively to address some of these concerns as their officers had to confront dangerous individuals who entered their station. The challenge with, one of the challenges with this bill is officers really have no way of knowing who is legally carrying a firearm. An open carry, it's a consensual encounter, and when the individual indicates they're done with that encounter, it's essentially done. With a CPL, we have additional avenues to further investigate, and as we know, Michigan is home to several of the most dangerous cities in the nation, and officers need to have the ability, under the interest of public safety and officer safety, to investigate individuals who do carry a gun, because sometimes individuals do carry guns with bad intention. Guns are dangerous, and in fact, we can look back a couple months, or within the last month, at the city of Livonia at a private range facility, for all intents and purposes, a highly trained range officer who was conducting training classes shot and injured the student while they were at the range. Obtaining a concealed pistol license requires a very minimal amount of training, and they do address the safe storage and handling of a weapon. Michigan Commission on Law Enforcement Standards, the governing body in the state of Michigan for police officers, recognizes how important, in fact, weapons training is, that they mandate a certain number of hours in the academy. And MCOLS, the Michigan Commission on Law Enforcement Standards, has one and only one post-academy requirement for our certified law enforcement officers. Their one requirement is an annual weapons qualification. That's for a reason, because weapons are dangerous, and we have to have some skill in handling weapons. The existing regulations have withstood court challenges, including from Justice Antonin Scalia, former Justice Antonin Scalia, who in 2008 wrote, "The right secured by the Second Amendment is not unlimited." That's from District of Columbia versus Heller. There's a very well-known risk manager who travels the country by the name of Gordon Graham, who teaches us if it's predictable, it's preventable, and we can see, based from past experience, that we can certainly anticipate some more harm coming from individuals in possession of weapons without training. So really, again, our concern at the Michigan Association of Chiefs of Police is that this is a public and officer safety issue, and therefore we oppose this package of legislation.
Thank you. We have Representative Cole.
Thank you, Mr. Chair. I'll be a little quicker on this one, I think. Thank you for being here very much and for what you do in the state of Michigan. Do you believe we have enough gun laws right now to handle gun crimes? Do you have the tools as a law enforcement officer to handle those illegal persons that carry a firearm for nefarious purposes?
I think there are a lot of gun laws right now, and there are some that are very confusing, including the open carry concerns that we're dealing with.
Well, open carry is really simple. If you are illegally allowed to possess a handgun, you can legally open carry that handgun. That's pretty simple.
That's correct, yep.
That's not
We're
confusing.
not arguing that, right.
All right. Do you believe if this doesn't pass, that the nefarious citizens or the folks that are illegal to possess a firearm or carry that firearm are going to stop carrying concealed?
No, but I think that it gives officers an avenue to investigate and contend with those individuals who are illegally carrying weapons.
But is it actually going to make anything any safer?
Certainly. It'll make the police officers safer who are able to further investigate these types of crimes.
But if you're a legal, law-abiding citizen, a legal gun owner, why should it be a crime if I put a coat on?
It's not a crime.
But it is right now, unless I have a CPL.
Right.
A law-abiding citizen.
Police officers have no way of determining that with this package of bills. We won't know if it's a crime or not because we can't investigate.
How would you know if I was open carrying if I was committing a crime or not? As a legal, law-abiding gun owner and citizen.
And we would say that the problem is with that right there, because we are called to scenes often where people are open carrying and they choose not to engage with the police officer and walk away. Absent that, we don't know whether that person is legally carrying or illegally carrying, so we would say there's a problem with the open carry, and we encounter that at police departments, such as after Sandy Hook, where open carry people show up at a school and the police arrived there. There's a problem with that also. So to just basically say we know a person is legally carrying open carry, we do not. And sometimes we can't determine that if the person chooses not to engage, if we're just called to the scene by a citizen that's concerned with the open carry person there.
What kind of suggestions do you have then for helping solve some of the illegal gun crimes that are out there, the people that are carrying illegally, that aren't allowed to even possess a firearm, much less carry it?
Well, the current CPL does allow proactive, when the police are out, they make stops in some of the dangerous cities and people have firearms. There is some avenues for us to investigate what they are doing with those guns. We do not think that everybody having a gun in those situations is good for the public and good for the officer's safety.
But that's a fine line, sir.
Well, we're out there dealing with that fine line, and we see the consequences when it falls the other way, and they're not good.
I understand, but we have the Second Amendment, and it protects my right to own and possess a firearm and to open carry that firearm. And I personally have a CPL. And so for law enforcement to look at me as someone that may have nefarious reasoning for carrying a firearm, that's sort of offensive.
Okay, next we have Representative Greimel.
Yeah, thank you, Mr. Chair. Before I ask a couple of questions I'd like to ask, I do just want to clarify, there may be folks viewing this that are a little confused. I wanted to clarify that the sheriff's letter who you read is from Berry County, I believe, not Berrien County. I thought there might be some confusion around that, given that the Berrien County Sheriff is on the board of the Michigan Sheriff's Association. So I just wanted to clarify that in case any viewers or listeners are confused. The questions I wanted to ask are, number one, my understanding is that the legislation before us would allow people convicted of some crimes who are currently prohibited from obtaining a CPL because of their conviction for those crimes to carry a concealed firearm in places where they're not currently allowed to carry that. And I wanted to give you the opportunity to express any concerns that you may have about allowing individuals to carry concealed firearms who are convicted of some crimes who currently cannot carry concealed firearms.
So I think the original, whatever the 68 enumerated crimes were enumerated with a purpose and for a reason, again, in the interest of public safety, and we would not support whittling that number down.
Okay. And the second question that's related is understanding that officers, deputies, troopers who are interacting with folks who learn during a interaction, maybe they're arresting somebody for a different crime, they learn that somebody is carrying a concealed firearm. Under existing law, it's quite easy for that officer or deputy or trooper to determine if that person is legally allowed to carry that simply by determining if the person has a CPL or doesn't have a CPL. In the absence of that licensing system, I would imagine that the only way that an officer or deputy could determine whether or not the person is legally authorized to carry a concealed firearm would be to know by memory all 68 offenses that prohibit someone from carrying a concealed firearm. And I wanted to ask you how realistic that is to expect every officer out there to just know off the top of their head all these enumerated offenses that would prohibit someone from carrying a concealed firearm.
I think the sheriff who preceded us articulated very nicely the challenges that our law enforcement officers face on a daily basis and having to make split-second decisions, particularly when it comes to their own safety and individuals armed with offensive weapons, to expect that they're going to know those 68 enumerated offenses is, I think, an unreasonable expectation for our officers.
And then my third and final question is, as a trained law enforcement officer who's gone through training to know when lethal force is authorized, to know when lethal force is not authorized, someone who has gone through firearms training to when lethal force is authorized to discharge the weapon in such a way that it minimizes risk to innocent bystanders. If you could comment on what it would mean for people to legally carry concealed firearms out in public for self-defense without going through any training about when lethal force is authorized, and without going through any training about how to properly use a firearm in a public space when lethal force is justified to minimize danger to surrounding innocent bystanders.
Yeah, and as my partner just highlighted, that's really even unfair to them, and I think you just really articulated that very concern. Our highly trained departments that are able to invest in training spend immense amounts of time working with officers on those very issues. And so to expect citizens who legally obtain a weapon because they meet their age and driver's license requirements, to know all of those concerns and considerations and liabilities around that is, again, I think a high expectation.
Thank you.
Representative LaFave. Any other questions for our speakers? I guess that is it. Thank you so much. Next, we have Tom Lambert of Michigan Open Carry. And who is with you there?
Members of the committee, my name is Tom Lambert. With me today is Dean Greenblatt. He is our corporate counsel. Mr. Greenblatt is a well-known firearms attorney in the state of Michigan and can speak to specifically how some of these laws work. I have testified on these bills already. I don't want to rehash anything I've already said. What I do have to talk about today is specifically the disqualifiers that were brought up last hearing. I've done an extensive, I do want to underscore that, an extensive amount of looking into these specific disqualifiers. There are two sets, an 8-year set that disqualify you for 8 years and a 3-year set that disqualify you for 3 years. There are 68, 69, 70, depending on how you count them, categories or statutes that are cited that are included in these two sets. Of the two sets, or of those 70 or so statutes that are cited, there are over 200 potential charges that someone could face. Of those over 200 potential charges, The majority of those are already felonies that would prohibit somebody from possessing a firearm completely. I do want to underscore that. We're not talking about just being precluded from having a CPL. We're not talking about just being precluded from carrying a concealed pistol. We're talking about possessing firearms entirely, even in your own home, on your own property. Still others would potentially disqualify the person depending on the circumstances involved. And then even more, especially the ones that involve Schedule I substances, would disqualify the person for at least a year. Then we get to some of the ones that are left. Now, I heard testimony just a minute ago that they would not be in support of whittling down this list at all. I would say the only person that would make a statement is someone who has not looked through this list. There are some very interesting ones in this list that I would like to point out. One is obstructing official weights and measures. Someone hindering or obstructing certain persons performing official weights and measures. And then the very next one is hindering, obstructing, assaulting, or committing bodily injury upon the Director of Department of Agriculture or authorized representative of the Director. I know of no other disqualifier for assaulting any other director. We have many in the state, so the Agriculture Department must have had a pretty good lobby here, or lobbyists, when they put this law through. Now, you might think, well, assaulting, that's pretty bad. Yeah, I agree with you, it is. But assault would come with that disqualifier as well, which would bring further punishments. There are many of these that, on their title, and if you want to bring any of these up, and I encourage you to please bring any up that do concern you, be careful with the title you read. Because the title applied in the statute, as well as the ones the Michigan State Police apply on their website, isn't necessarily the specific one that disqualifies you. And I want to give you an example. Fourth-degree child abuse. Anyone raise your hand that thinks child abuse is okay? Yeah, I didn't expect anyone to raise their hand there. Fourth-degree child abuse, specifically as the one that's pointed to in there, is not somebody beating up their child. That one is specifically more of a neglect issue, where a parent was supposed to do something, and because they didn't, their child could have potentially faced harm. It doesn't even require harm there. And that's an 8-year disqualifier. Another one that's on its face, displaying sexually explicit material to a minor. Under that one, giving an adult magazine to a 17-year-old could cause you to lose your CPL for 8 years. I'm not going to defend anyone that does that, but I will suggest to you that losing your CPL for 8 years perhaps is a bit overkill. And under this legislation, if we wanted to apply it here, I would absolutely suggest to you that is quite overkill. I do want to highlight just a few more, if you'll bear with me. There's 3 of these disqualifiers. 2 specifically are currently being repealed and are in front of this committee already and have sailed through the Senate already. One, not of those 2, but additional to those 2, was repealed more than 8 years ago, and therefore anybody convicted of it, it's impossible for it even to be a disqualifier anymore. So even if we said, yes, it should be a disqualifier, there's nobody left that it would disqualify. So I would hope we can all agree, at least we can whittle that very one down. We get into the 3-year disqualifiers, and we get even more weird. Refusal of a commercial motor vehicle to submit to a preliminary breath test. So if you're a commercial driver and you just refuse to commit to a breath test, which you can do and face punishments for that, well, then that's a 3-year one. Operating a locomotive while under the influence. A whole lot of that going on. Where was it? Petty larceny. Petty retail fraud, petty embezzlement. And where, again, I urge you to be careful with the titles applied here, is the vast majority of these have misdemeanors in them and they have felonies in them. So when we think of these titles, we think, oh, well, that could be a really bad situation. And you're right, it absolutely could be. But when it is a bad situation, there are further punishments that apply there. There are the felonies that would apply in that situation that, okay, this really is a bad situation, that's where those disqualifiers would apply. That's my assessment of this list and I would urge questions of any that do concern you, and I'd be happy to address them. But I would like to turn it over to Mr. Greenblatt here to talk about how probation works for any of these misdemeanors, where even if this specific misdemeanor does not disqualify you directly under federal state law, the probationary period afterwards is still another story.
Good afternoon, Mr. Chair, members of the committee. My name is Dean Greenblatt. I'm a resident of Bloomfield Township, Michigan, and it's my honor to appear today to express my support for this package of bills and to answer specific questions. In addressing some of the issues that Mr. Lambert brought up, and then I did prepare an examination that might be helpful for the committee, specifically having to do with the 3-year exclusions under the existing Concealed Pistol Licensure Act, and how these particular offenses, if they're not applied through that statute to people that are constitutionally carrying, how they might be applied through the court system in any case. Any individual who is arraigned for a misdemeanor, including all the offenses that are listed in the Concealed Pistol Act as 3-year disqualifiers, and not incarcerated, will be issued either a pretrial release order or a bond with terms and conditions, or both. Everybody who's arraigned has to have these forms completed by a district court judge or a magistrate. In each, the bond and the pretrial release order, there are selections that, in the discretion of the court, if they determine that there's a threat to the public or to a specific individual, may select a term or condition that will, and I will quote, not possess or purchase a firearm or other dangerous weapon. That's item 11 under the pretrial release order or a bond order that would be issued by a court. Additionally, MCL 771.3, subsection 2O and 3, allow that a defendant be able or be subject to conditions reasonably necessary for the protection of one or more named persons. The court may impose other lawful conditions of probation if the circumstances of the case warrant or in its judgment are proper. The point here, and to sum it up, is that a judge, in their discretion, in the discretion of a court, in any misdemeanor case, can choose, and typically do choose, to impose these conditions of bond or conditions of pretrial release that will eliminate the ability of anyone to possess a firearm or ammunition, let alone carry it. So the protections for the public are there in cases of misdemeanors where, in the court's discretion, they determine that there's a threat. And it's not necessary, I think, to have it written into a statute to specifically preclude these and remove the discretion from the court.
I do have one final comment very quickly. There was a comment made about the officers would have to make a split-second decision when thinking about this. That's not necessarily the case when somebody is properly detained. It sounds like not everybody that's testified likes the Fourth Amendment, but when somebody is properly detained, openly concealed, they can go through lean and take a look at this. The focus on this committee has been with open carry and concealed carry, and I would like to bring one more thing that you should think of, and that's just the mere possession of a firearm, transportation of a firearm. It's in my trunk. So in that case, an officer, if they wanted to and they had reason to believe, would have to determine whether or not that person could have the firearm in the trunk. So in addition to open carry, in addition to licensed concealed carry today, there are numerous people, especially in hunting seasons, that possess firearms in Michigan. They transport them, they don't necessarily carry them. And when they come into contact with officers, an officer, at their discretion, would need to determine if they can lawfully possess that firearm. So how do they do that today? I would say ask them, and that's exactly how they would do this under these bills, or how they would determine somebody who can lawfully possess a concealed pistol.
Thank you. Representative Cole.
Thank you, Mr. Chair. Thank you guys for your testimony very much. A fairly straightforward question for you. In constitutional carry states, has there been or has there been seen a rise in law enforcement endangerment or deaths by lawful gun owners who are carrying concealed?
Not to our knowledge.
So the states that have moved, and how many states, can you remind me how many states have gone constitutional carry?
I believe there are 13 as of today. One has always been this, and there are 20 more with legislation pending.
Okay, so in these states that have gone this route, there has not been a rise in or an increase in dangerous interactions with law enforcement by law-abiding gun owners?
Not to our knowledge.
Thank you.
Thank you. Representative Grimel.
Yeah, thank you for your testimony again today. If you could, can you run through the entire list of offenses? I know that you've cherry-picked a few offenses that don't sound on the face of it all that
We've got a lot of people here.
I just want to make sure that we're getting a full flavor for all the offenses that currently prohibit someone from getting a CPL that no longer would prevent somebody from carrying a concealed firearm.
We can make sure and get that to the committee, but I'm not going to take the time to run through all of these offenses.
I've got a couple more questions. We obviously have situations where people, despite having a criminal record, don't want to violate the law when it comes to carrying a concealed firearm, apply for a concealed carry permit, and then learn, perhaps for the first time, that they have committed a crime and been convicted of a crime that prohibits them from carrying a concealed firearm under the current CPL laws of the state. And those are people who, despite having a crime in their background, may be well-intentioned now, don't want to violate the law. But if we get rid of the CPL process, there's really no clear way for those people to learn that they've been committed of a crime that prohibits them from carrying a concealed firearm. Is that right?
Really quick, you said get rid of the CPL process. I think you just mean exempt these specific people from the CPL because
That's right.
we're not getting rid of the CPL process.
Yeah, but you're making it purely voluntary.
Right. For specific areas. As I outlined, the majority of these, when we get down to the specific charges, the majority of them are complete disqualifiers. And they would get that anytime they apply for a purchase permit, anytime they go to buy a gun from a gun store, they would learn of those. The ones that are not in there that would not disqualify them federally, they could learn about those as they get a purchase permit under state law. The last few that are not in there, I would suggest to you that necessarily shouldn't be in there at all.
And two last questions. One last question for you, and that is, you, I'm sure, agree that, to use your example of child abuse, that there are many situations where someone is charged with a more serious crime that is then pleaded down to, say, fourth-degree child abuse, correct?
I could imagine there's a situation like that would exist.
And my last question for you, Mr. Chair, is since we've allowed Michigan Open Carry to come up and testify for a second time, in part to rebut other testimony, I assume that you will accord the same courtesy to law enforcement groups if they so desire?
Sure. If we've got a lot more first-time testifiers here to go, but we'll hopefully have time to circle back.
For what it's worth, I know the disqualifiers were a big issue last time. I wanted to do research, and I asked for time to speak specifically to that issue and no others.
And if there's no other questions, thank you for your time. And we have the Michigan State Police, Sergeant Tim Fitzgerald.
Thank you, Mr. Chairman. If it's okay, Sergeant Matt Williams is going to join me up here.
Absolutely.
Thank you, Mr. Chairman and committee members. We'll get right to it. MSP is opposed to the bills, the package of bills as written. I would say that there are really two issues for us. They're just missing two what we think are critically important pieces. One is disclosure. We think that it's common sense if somebody's carrying a vehicle or somebody's carrying a firearm in a vehicle, that they disclose that when they have a contact with the police officer. In this time, in this day and age, when we are increasingly pushing our people to get into a sort of a de-escalation mode, we're trying to start things and keep them at the lowest possible level, a conversational level. The inclusion of the statement that you're carrying a firearm is actually a relief. Some people don't think that. Some people might think that that gives us some pause. But as it is now, and it has been my experience on the road making traffic stops, When I have a CPR holder identify himself and tell me that he's carrying, that immediately kind of diffuses the situation for me, because I know I have somebody that's following the law, and I know I have somebody that I'm very unlikely to have a problem with. So that's the biggest piece of disclosure. And I would say, and I would share with the committee, that we have been talking and working with Representative Runstead on some disclosure language. We're trying to get to a place, I don't think we're quite there yet, but I would describe those discussions as productive. And we're definitely moving in a positive direction, I think, on the disclosure piece. The second piece for MSP is training. I understand that people voluntarily seek out training, but I think that as a public safety agency, we have to make sure that people that are heading out carrying firearms understand the full breadth of what they're getting into. Use of force, all the laws that go with it, civil liability. We've been great partners really with the NRA and their curriculum through this CPL process. Some have described it as sort of a minimalist process, but it is something. It's 8 hours of instruction. And when we talk to the NRA instructors, I've had conversations with several of them over the last few weeks. They tell me that that's a critical piece of their class. People are on the edge of their seats, and people are learning things, and people are really grasping details that they never even considered about this whole world of carrying a firearm in self-defense and just in your everyday operation. So that's a piece that we think is also very important. There are some other things that I would bring up just sort of anecdotally, just so you're aware that we had, last year we had 3,982 people that were either licensed, their license was suspended or revoked in the process because of committing a disqualifier. Okay, so right now we have RAP back, which notifies us, and I wasn't quite able to hear all the testimony from Mr. Lambert, but we have RAP back now with CPL. With constitutional carry, I just provide a point of information that we would be losing that ability. We will not know automatically if somebody committed a statutory disqualifier. We'll be kind of relying on them for their own discretion. So that's just a piece of information that I want to provide to the committee. Again, I think the discussions we've had have been productive, and I think that I actually have been surprised that we've made the progress that we have. So I thank the chair for his work on that, and we'd be happy to take any questions.
Yes, I appreciate the willingness to work on, the disclosure provision, and I think we may be able to get there with language on that. And with that, Representative Lefebvre.
Thank you guys so much for coming in. I have kind of an interesting question. From a 10,000-foot level looking down, are you familiar with any officer who's arrested an individual they came in contact with for the sole reason that the person refused to speak to the officer?
I guess I'm not aware of any specific instances where that's happened. Do you have one in mind?
Well, I'm thinking in a hypothetical. Okay. So if, for whatever reason, I'm having a bad day, and the deputy comes up to the car and asks me the typical question, license, registration, proof of insurance, and I hand the paperwork over, I'm not legally required to say anything, right?
Right, correct.
So I don't understand why you're forcing me to disclose that I have a weapon if under the Constitution I don't have to say anything. I think this whole disclosure, I get how it sounds good, but the fact of the matter is I have a Fourth Amendment and a Fifth Amendment right, and exercising my Second Amendment right shouldn't diminish or exclude me from being able to use the Fourth or the Fifth. So I don't believe the disclosure on the current CPL law is constitutional, and for that reason alone, I'd be disappointed if we had to disclose in the future because, frankly, I think that it is quite clear, if we have a disclosure part in there, that me exercising my Second Amendment right is now diminishing my ability to exercise other rights under the Constitution. Do you guys see that differently?
Well, going back to your scenario, you're handing over your license, registration, and proof of insurance. So you are disclosing that you have insurance. You are disclosing that your registration is valid.
Yeah, but I don't have a right under the Constitution to drive on a public highway. But I do have a right to the Fifth Amendment, Fourth Amendment, Second Amendment, First Amendment. So we've litigated all of the license, registration, and proof of insurance for a vehicle. I don't think we properly litigated the Second Amendment versus Fourth and Fifth argument. I really don't. And I would love the Supreme Court to come in on it if we can't do it in the legislature. But
I believe they did in 2008,
how was that?
where they decided, and there was a majority opinion written, that the states could in fact regulate to a certain extent.
Or are you talking about the Heller case?
Heller opinion, yes.
Yeah, not what I'm talking about. I mean the Michigan Supreme Court on specifically the disclosure piece. But I really do respect your organization, and although we might not agree on this one, I thank you very much for your service.
Next, we have Representative Cole.
Thank you, Mr. Chair. Thank you guys for being here as always. I want to ask you the same question that I asked Tom Lambert. And he couldn't recall any rise in law enforcement endangerment or deaths when these states went to constitutional carry. So do you think Michigan's going to be any different?
In law enforcement deaths, I don't think that it will change the number of law enforcement deaths at all. The pieces that we're talking about are training and disclosure. And again, I know Sergeant Fitzgerald already said it, but Tom and the other groups have been great to work with. We've been having a lot of discussions with them, and it has been, I think, a productive process. But the two main issues we're concerned with are disclosure and the training, which doesn't necessarily speak to the danger of a law enforcement officer being shot or killed, because most likely a person isn't going to disclose if they're going to shoot a police officer, correct? I think you're probably of the same opinion. It's more to help guide that interaction between us and a law-abiding citizen.
To the training aspect,
Yes.
Right now, you're not required to have any specific training to open carry as a legal law-abiding gun owner to possess that handgun in open carry. What changes when you put a jacket on?
Not a lot changes, but that also doesn't make that the right point, in our opinion. Our opinion, training, there should be training for all of the scenario, the whole thing.
Okay,
even
then-
open carry. So that's where we will disagree on that.
Okay. Understand. Would you support mandatory gun safety training in schools?
I think we could definitely look at that.
Thank you.
Next, we have Representative Guerra.
Thank you, Mr. Chair. I think we've discussed a little bit, but I think it's important to actually ask officers who are on the road that deal with this every day.
But you're
So
still
if
going to
this-
ask us anyway?
If this legislation were to pass without the disclosure piece, how would you know if someone that should not legally have a gun has a gun?
Well, that's a fair point, Representative. We likely may never know. The worst possible scenario is we see it or observe it before either it's disclosed or before there's any other interaction to determine where we're at. And again, all this is in the totality of the circumstances. It depends where we're working. I would say to some degree officer safety is consistent, but we are going to treat things in Escanaba maybe a little different than we're going to treat them in Inkster. So it's sort of case by case.
Right. And then my second question, the previous person who gave testimony mentioned, I don't know if it was a Michigan Supreme Court case or a United States Supreme Court case about the time frame in which you should have a traffic stop. Do you recall, was it 20 minutes?
So it's approximately 20 minutes. There's been a court case about reasonableness.
Yeah, they didn't give a specific time. It's just
Okay.
it's a reasonableness standard.
Okay, do you anticipate that this will extend the time frame that you have in which you're able to have a discussion with someone you pull over?
It very well could, until a system was put in place to determine whether someone's lawfully possessing that gun. But again, to the disqualifier piece and Mr. Lambert's testimony, those are things we're willing to look at and work on.
Thank you.
Next, we have Representative Greimel.
Yeah, thank you for your testimony today. I just wanted to ask some questions and follow up to the representative from Dickinson County's questions. Would you agree that the courts have clearly and consistently held that the right to bear arms is not limitless? For example, people can be prohibited from owning or possessing or carrying in a concealed manner firearms if they've been convicted of certain crimes?
Yes, sir.
And that's similar to the fact that courts have held that the First Amendment right to free speech is not limitless, that, for example, someone can't yell fire in a crowded theater.
Yes, sir.
And would you also agree that the same reason why the Fifth Amendment does not give motorists a right to remain silent when asked to show their insurance certificate, for example, is the same reason why you don't have to Mirandize motorists during a traffic stop, and that is that the right to the Fifth Amendment does not come into play until someone's taken into custody?
Yes, sir. That is correct. Custodial. It's a custodial detention at that point.
Thank you.
Representative Sowerby.
Thank you, Mr. Chairman. Thanks for your testimony today. Is it your opinion, as we look at population centers and populations of states, Michigan is 9.9 million people and has densely populated big cities, densely populated suburbs, all that. And it's been spoken to quite a bit of the 12 permitless carry states that, allow this to happen. 10 of those 12, excluding Missouri, which has 6 million population, and Arizona that has 6.9 million population. The remaining 10 have a total of 15 million population, some as small as roughly 500,000 total population. Do you feel that in a state like Michigan, which is so densely populated in many areas, that this becomes one of the concerns that the state police and other police agencies may have in allowing the permitless carry in states like us, which are so heavily populated? If you could speak to that, and especially in comparison with those other 10 states I spoke to, separate of Arizona and Missouri.
Absolutely, Representative. I think that's a very fair point. And, we also in Michigan possess some of the most dangerous and violent cities in the country per capita. That's why we have the Secure Cities Partnership. That's why we have special investigation teams and focus in some of those cities. And while we have made some strides, we still have some pretty big fights that we're battling in those cities. I don't think this helps, and I don't think it's the same thing. Just as I alluded to how enforcement might be a little different in the UP than it is in Inkster, that's kind of the same argument. We're going to have a little bit of more trouble with this in Inkster, clearly.
Thank you. Thank you, Mr. Chair.
Any other questions? I would just comment personally that Phoenix, I would say, has got quite compressed population, and I'm sure some high crime areas compared to some areas of Michigan that are more rural, so I'm not sure that necessarily would adhere. But if there's no other questions, I will thank you again for your testimony. Next, we have Louise Wright for the Coalition for Common Ground. While we're waiting for Louise Wright, on the deck, waiting is Judy Olson. Will be after Louise Wright, and if Louise Wright doesn't appear here shortly, we will go to Judy Olson. Okay, we're going to go to Judy Olson, if Judy is here. And she is representing herself. If we don't see Judy Olson, the next person with a card is Marjorie Weldon, representing herself. And there is Marjorie. Welcome, and begin when you're ready.
Good afternoon. I'm just representing myself, and I'm highly opposed to this package of legislation. I don't think it makes any of us any safer, and I can't imagine why anybody would have a gun and not have training and a license for it. We have to have a license to drive a car. It just doesn't make sense. You know, I'm the last person in the world that would say that you don't have a right to own a gun, but it seems like you ought to know how to use it, and you ought to have a permit, and you ought to not be crazy. That's it.
No, I don't see any questions. Thank you very much for your testimony. Next, we have Cheryl Farmer, Physicians for the Prevention of Gun Violence. And up next is going to be Terry Link, will be after Cheryl Farmer.
Good afternoon, I'm Dr. Cheryl Farmer. Can you hear me?
Turn it on.
Thank you. I'm a retired internist and a member of the Michigan State Medical Society Committees on Legislation and Bioethics. I was mayor of Ypsilanti for 12 years, and I'm a member of the Physicians for the Prevention of Gun Violence, which is a group looking at how to decrease gun violence from a public health perspective. I had 4 years of undergraduate education and 4 years of medical school training before I was licensed to use a stethoscope with the potential to save a life. The idea that we as a society would want to entrust people with guns that can so easily be used to take a life, who have no training whatsoever, who have no license, makes no sense. We have a serious problem with gun violence in this country. I would go so far to say as to say that we have an epidemic of gun violence in this country, and I want to share with you some statistics. This comes from the American Journal of Medicine, March 2016, with the title Violent Death Rates, the U.S. Compared with Other High-Income Countries, 2010. The method was to study the 2010 mortality data obtained from the World Health Organization for 23 populous high-income countries, and then to calculate the death rates per 100,000 population for each country and compare. In the United States, the gun homicide rate was 25.2 times higher than the next closest country. For 15 to 24-year-olds, the gun homicide rate in the United States was 49 times higher than the next closest country. The conclusion was that the United States has an enormous firearm problem compared with other high-income countries. And if you're interested, I could get the whole study for you to review. I'm opposed to this bill and to the entire set of bills currently being proposed that would make it easier for people to obtain a lethal weapon without a license and without training. I believe these bills will make our gun violence problem worse, not better. Not long ago, we had yet another shooter on yet another campus, and as it happened, two of the students were military veterans, licensed to carry, and in fact had their firearms on them. They knew one another, and they conferred. Should they go looking for the shooter to try to help? After conferring, they decided no, that in the heat of the moment, the police officers responding to the call might mistake them for the shooter. This heroic notion by well-meaning people that if everyone was armed, no one would get hurt, is not supported by the data. That good guys with guns would take out the bad guys with guns is not supported by the data. I oppose this bill. I oppose the related bills that are up for discussion today for myself and on behalf of the 800-plus members of the Physicians for the Prevention of Gun Violence. In conclusion, I'd just like to say that in my 30 years of practice, I lost a few patients despite my best efforts. Even now, I sometimes feel the weight of the decisions that I made and wonder if I should have made a different decision, and would that have had a different and a better outcome. If you decide to make it easier for people to obtain a firearm, we can predict that firearm deaths will rise. Will all of you feel the weight of this decision? Actions have consequences. To quote an earlier speaker, if it's predictable, it's preventable. I thank you for this opportunity to speak.
Thank you. And just to clarify, the bill package does not make it easier to obtain. That stays the same. You still have to go through a background check to purchase. Nothing changes on obtaining.
The need to train?
No, obtain. You said making it easier to obtain.
If you
about
don't
4 or
have to
5 times.
train to obtain, that makes it easier to obtain, does it not?
You don't currently have to. You don't have to now. No, I'm just clarifying that there's nothing in this bill package that changes the requirements to obtain a weapon. There's no change in obtaining a weapon. Currently, and if this bill package passes, the requirements to go through a background check will still adhere. There will be no change to obtain a weapon.
Okay, thank you for that clarification. Then, for me to clarify my comments, I would just like to add that it changes the dynamic of gun ownership if there's no requirement to train.
Which is currently 30, the training is 30 rounds. There's a lot of misconception about that. How much training we're talking about? 30 rounds, about a box of ammunition.
So the current training
for concealed carry, yeah.
may be inadequate. Is that what you're telling me? That's how it sounds.
I've been a shooter, and I've shot many boxes. And if I was going to be, I don't conceal carry. If I did, I personally would. But requiring any more or less is, I don't think, is going to make a person necessarily better at anything along those lines. This is something that really is a personal responsibility. I'm sure most of the people I know who carry a concealed weapon and will continue are regularly shooting. It's just what they do, is whether there's a requirement or not a requirement. And I'll bet that's the case in the 13 states that don't require it, because the people go ahead and take the class anyway, even at a higher rate in the states that have eliminated it. But most people that carry, I know personally, do shoot quite a bit, required or not. So thank you so much for your time. And next we have Terry Link of the Peace Education Center. Go ahead.
I think that training is definitely a good thing. I would like to mention, though, that the third leading cause of death in the United States is physician's error. So to find a group that are physicians against gun violence going after a portion.
Okay, let's move along here. I want to make sure we've got a lot more cards to go. So, Mr. Link, go right ahead.
Thank you, Mr. Chairman and committee members, for hearing my testimony today. My name is Terry Link. I live in Langsburg, Michigan. I am co-chair of the Peace Education Center. I am not speaking for the Peace Education Center today. I'm also a senior fellow with the U.S. Partnership for Education for Sustainable Development and a former county commissioner, among many other things. I'm here to voice my opposition to 4416 and the subsequent bills. And I'd like to take a page off of Representative LaFave's comment earlier, which I appreciated. And instead of taking off at 10,000 feet, I want to take you up to 30,000, 50,000, maybe 100,000 feet look at this issue that I haven't heard in the previous hearings or yet today. There seems to be an insidious disease, to kind of take off from the previous speaker, that's permeating our society. And this disease is being fed by the media, by motion pictures, by television, by our own government. And it's a disease of violence. It's a disease of organized violence. The endless growth in the spread of weapons. Just this week, we had another $100 million of weapons being okayed for Saudi Arabia, another $30 billion set up for Israel. The president's budget, which was released today, asked for an additional $54 billion for weapons and the military. Even Vietnam is now eligible to receive weapons from the United States. The beneficiaries of this disease are the weapons makers. They're the ones that profit from it. Major firms like Lockheed Martin and others have talked about how tensions in various parts of the world make their profits go up. I think we need to look at this escalation of the disease as it affects us, not just at the federal level and the global level, but how it permeates the society down here. Escalating fear, which helps drive this. If we're afraid of somebody, if we're afraid of the Russians, or if we're afraid of the Chinese, or if we're afraid of our next door neighbor, we're told that the way to do this is to arm ourselves. And this fear has got to end. It's on an escalator to nowhere. Those who believe that they can bully less well-armed into submission are sowing the seeds of blowback. It's the dispossessed of this world that are arguably pushing forth because they have no other place to go. We're spending our dollars and our time instead of solving the problems of the humanity faces. We're not even talking yet about climate.
Can we contain more to this bill package? I'm going to get too far afield from...
The bill package is based on an idea that we need more weapons in our culture. I'm trying to argue that we don't need more weapons in our culture. I don't feel safe when I'm walking down the street and I see all these guns, unless they're in the hands of our police officials. I think that we really need to consider this violence as a social element, and that loading and letting everybody carry guns in public is not the way to make it feel safer. So I'm totally against this bill, and I would have us think about how to de-escalate violence. And I don't think it's by adding more violence or more guns. There's enough guns. There's too many guns. And I'll stop there. But the point is that it's part of a bigger issue that this is embedded in. And if we think we can fix it at this one level and ignore all the rest, I think that's a problem.
Thank you. Any questions? Apparently not. Thank you so much for your... Oh, I'm sorry, Representative Cole.
Thank you, Mr. Chair. Do you support the Constitution?
Absolutely.
Do you support the Second Amendment?
Yes, I do.
In your testimony, it sure doesn't come across that way, sir.
Well, I didn't say there was anything wrong with having a gun. I don't want the guns out in public. I think you should have a gun. The Second Amendment says you have the right to keep arms. The Second Amendment was done at the beginning of our country. At that same time, in that part of the Constitution, we also said that blacks and women didn't count. So does that mean that the Constitution was always right the way it was written before?
So
we have amended the Constitution.
So you're opposed to my right to self-defense and my ability to carry my firearm?
Not at all at home. Not at all when you're out hunting. But I do have a problem with people carrying them out in public. I'd feel much safer if I knew going out in public that the only people that legally had guns out there were the police officers.
Thank you.
Representative Yarrow.
I just have a question, about more states that, if states that don't require training, that more people have actually participated. MCRGO, I think, mentioned that data as well. Could you share with us that data?
Yeah, but I don't happen to have it in front of me.
Right, not
but
the second,
certainly,
but- okay,
absolutely, we'll
thank
get
you.
that to you. If there's Representative Homer. Okay. Next, we have Gloria Thomas of the Michigan Coalition to Prevent Gun Violence, representing herself. Is Gloria here? If Gloria is not here, we will go to Deputy Al and Mary Potowski, Self-Enforcement Reserve Officers Training. Welcome, and begin as soon as you arrive.
Thank you, Mr. Chairman, state representatives, for allowing us to testify today. As a law enforcement firearm instructor and member of ILETA, ILFE, NAFTO, and OSDA, I am a specialist in teaching female officers. Experts agree that women learn differently than men. Too often in my 22 years as a firearm instructor, what I hear is the first exposure to handguns by a lady is when she's dragged to the shooting range by a boyfriend, husband, or family member and handed a large caliber weapon, which results in an unpleasant experience or worse, injury. As a woman, I know that attention to detail, such as proper way a lady puts on her hearing protection muffs when she has long hair to properly protect her hearing from gunfire, realizing that size and fit of the weapon is important, and her gradual introduction to handguns is paramount in safe handling and markswomanship. When considering concealed carry, how women carry is important. The lawmakers, with the input of law enforcement back in 2000, had it correct when they included pistol safety training as a requirement of the permit process. Consider how a woman carries her gun as an off-duty officer or a citizen in a concealed carry purse. In gun training, women need to know how to properly carry a firearm to protect child safety. In the case of CPL holder Shakobi Green, it is my opinion that she only placed her personal protection handgun in her unsecured purse because she had a permit to carry in public. Otherwise, it would have been locked up at home. However, she did not use a lockable concealment purse readily available on the internet when her 9-year-old son reached into her unsecured purse and shot himself in the hand. Training is important, especially for women. Please note that Detroit Police Chief James Craig is quoted to the Channel 4 News saying, quotes, "I do support law-abiding citizens to have CPLs, but I've also indicated a very strong way the importance of training," end of quote. At my training academy, I add the extra information and training women need to keep them and everyone else safe with firearms. I did not hear any convincing evidence during last week's testimony of increased interest of even the most basic of firearm training for carrying a gun in public. In fact, as the owner of my own shooting range, I personally experienced the opposite is true, and it was alluded earlier. What I hear most often is one of 3 excuses for the average person interested in carrying a gun in public. First, a person would call and say to me, "I understand I have to take a pistol safety training course in order to get my carry permit. How fast can I get it? How cheap is the fee?" Or number 2, "I'm calling just to shoot. I don't want or need any training. I already got my CPL." And sometimes adding, "I just want to take," you fill in the blank, "my girlfriend, my wife, my daughter to the range to shoot my guns. They never shot a gun before." Carrying a gun in public for personal protection is not about women on target programs, hunting, or recreational shooting. Even the NRA states in their personal protection programs, and I quote, "Watching videos and reading books is no substitute for training under the tutorage of a competent instructor."
As a reserve officer in 2 of Michigan's largest law enforcement departments, I have either taught reserve officers firearm handling skills or qualified them annually in state-mandated qualifications for the past 11 years. Considering that in 85% of the violent confrontations with officers affecting an arrest or citizens as victims of a violent encounter, it happens at night. MCOLS has mandated incorporating low-light qualifying in the annual firearm qualifications in these past few years. Some reserve officers had difficulty passing the course the first time around. Yet it is reasonable that in a gunfight you may not get a second chance. How many gun owners practice in low light with their firearms? I've been in many situations, both in the Navy and as a reserve officer, when guns have been drawn and pointed at me and others. I have had experience including, but not limited to, an active hostage engagement, participated in multiple after-hour bar complaints assisting in arrests, with suspect detention and transporting those detainees to jail, felony sweeps, and criminal sexual conduct parole violator enforcement. It is clear that a person never rises to the occasion. They can only fall to the level of training in a potentially violent encounter. It is understood clearly that we expect our military and our law enforcement to protect us from both enemies, foreign and domestic. So we as a society require both constant training and qualifications of them. We are confident they can safely and effectively do their jobs. How can a constitutional carry citizen claim not to need any of this? that somehow that they are above our military and law enforcement without knowing what it is like to be in a violent encounter with a criminal. Insane active shooters or now even terrorist attacks without training or firearm qualification prove that they can perform defensive shooting under stress in the most adverse conditions. Please consider the current CPL law requires only one successful completion of a pistol safety course upon application. If a CPL holder takes a class or took a class in 2001 and renewed it in a timely fashion to keep it current, then that CPL citizen would have only taken one course in the last 16 years. The review of training requirement by law states that the applicant review his or her training materials for 3 hours and experience 1 hour of live fire range time, all on their own by the honor system. No certificate of completion is required. Keep in mind that the original course materials would have contained material of 16 years ago, void of any new laws, updates, or tactical improvements in firearm training. As an officer, I am concerned that the group of citizens who decide not to apply for a permit can carry a gun concealed on their person by only passing the simple background check of purchasing a handgun on Federal Form 4473 with a simple 12-question survey and a brief BATF background check. However, the CPL application disqualifies an applicant of any one of 23 misdemeanors within the last 3 years of application and 45 misdemeanors violations within the last 8 years prior to application. I made copies for all the committee members. It's in front of you now. I will conclude by thanking the state legislatures and the governor who passed Public Act 122 in 2012, the legal right of a Michigan CPL holder to purchase, possess, and use a taser for personal defense. Tasers have increasingly saved many officers and suspects from injuries by quickly and effectively diffusing what may have escalated to a potentially dangerous situation. It is easy to re-examine many CPL citizens who use their use of excessive force cases here in Michigan, whereas a CPL holder only carried a firearm without including the legal option of a taser or pepper spray, where people either ended up injured, dead, or in prison because they did not understand the difference of deadly force versus physical force. Most officers carry both. In conclusion, we in law enforcement carry guns to protect ourselves and the public with thorough training, firearm qualification, and departmental use of force policies. Our permit system is working well. Let's not confuse the general public by dividing into two groups, with and without the permit system. No one has proven, at this point, to me, a law enforcement reserve officer, that everyone will be safer in public. Thank you.
Thank you. Representative Hornberger?
I have some questions. Can you tell us, when you're speaking about women carrying guns, where's the safest place for someone to carry their weapon?
I think that depends on how the woman wears her apparel, her dress, and where she's going, what the situation is on a daily basis. So there's not one answer for that.
So is it safer for the gun to be carried on your person or in your purse?
I find myself carrying both ways, and again, depending on what my particular situation is. Is it safer? I think if you're well-trained, it can be safe in either situation. And is as safe.
In my CPL class that I took, in any other instance, and any woman that I know that carries, and any man that I know that carries, we've all been taught that the safest place to carry your weapon is on your body, not in a purse. You know, we can agree or disagree about that. I have some other questions. When you talk about fit for a woman, is fitting a gun important for no matter who the person is?
It's for both men and women, of course.
Right, because Rep. LaFave might carry something different than I might be comfortable carrying.
Of course.
If someone's smaller than me, like Rep. Hoytinga, she may carry something smaller than I would be comfortable carrying. So I think some of the things that you laid out here in reference to women carrying is a little off-putting as a woman who carries, that I may need different training or more training than a man. I think it's a little off-putting when in gun training women need to know how to properly carry a firearm to protect child safety. I would hope that all people carrying a firearm would be properly trained in all aspects, including child safety, whether it's a woman or a man. I just find some of the statements that you made here very, very off-putting as a woman who carries.
And the whole point of that was that training is essential.
For
And
men
if
and
the
women.
training, for both men and women. And if the training element is eliminated, basically because people are not required to take a class, I find, as I stated, that most people would not invest in that time spent and would just be carrying in unsafe manners and without the proper legalities and
But we
understanding.
have found that in states that do not require training, that most gun owners, men and women, will go out and seek out the training on their own.
I haven't seen the statistics on that.
Can I add something to that?
Sure.
Yeah, Representative Hornberger, when you do carry in a purse, so you carry a purse that
I
has
don't
a
carry
lot
in a
of-
purse.
You do not carry
I
in a
never
purse?
carry in a purse,
Okay,
no.
so would you agree that any woman that does, and in 22 years, we've noticed that most women do?
No female that I know carries in a purse.
But are you an instructor? Have you been through thousands of
No,
people?
I haven't.
Well, we have 22 years. We have thousands of people through our program, and most of those women carry a purse. Also, I mentioned, and men know this, that women wear form-fitting clothes. It's very difficult for them to carry the tactical holsters that our brothers at arms here, that Michigan Open Carry has. And when you do carry on your person, I noticed that you didn't mention anything about level 1, 2, and 3 as an officer in a very congested area, which I've been in, both in rock concerts and the public and the auto shows. I'm very concerned about when I'm open carry. Most officers are open carry. And that somebody, because I know, and we would all agree, I'm sure you would agree with this, that when criminals are in prison, they are training each other how to disarm officers. And they do that by disarming the officers. Now, if you don't have the level 1, now my sheriff, Mike Sexton, actually had a level 1, which is one step higher than having just a tactical horse that Michigan Open Carry has with them now, from what I can see. That means that's one more level of protection that somebody's going to disarm them in a public area, in fact, and even in this room. So the training and the education is nothing to be slighted against a person. But each person is different, each need is different. But if we're talking open carry, we're talking concealed carry, we need to get back to the talking points. Why are you carrying that firearm for personal defense? And are you protecting the 9-year-old son of Jacoby Green? Where's his rights when he reached inside that purse? That woman, how do you know that she actually was taught in the class that you will be obligated to carry a purse with a lock on it, that you can have access to it, and they're readily available? So we are not being pretentious to any particular group, we're not being sexist. Everyone has it right, but there is a need for everybody. I think everyone here needs to get back to the talking point. It's not constitutional carry that we're disparaging. I have about 70 pages that we have submitted to you now, and there are many reports and documents from our founders that said, and the first 2 words of the Second Amendment is well-regulated. Many reports that they wanted a well-trained. We want everyone that's law-abiding in Michigan to have firearms. We disagree with the anti-gun people. They don't like us. We disagree with a lot of the people that should have concealed carry. They don't agree with us. We come from the law enforcement trainer standpoint. If you want somebody to carry a firearm and it's going to protect you, how do I know as an officer, if my officer doesn't pass my qualification, that I'm going to be in the patrol car and feel safe that officer didn't pass qualification? How do I know if Representative Cole, with all the discussion he's had, that I know that in this room this is an active shooter, that he's going to be able to protect me, my wife, and everyone else in here? If they do what I asked to do in the last testimony, and that includes annual qualifications, the minimum standards what MCO puts out for law enforcement, then if he's pulled over and they see the annual qualification on his permit, then we know, we feel confident that he or yourself can actually protect us, law enforcement as well as the citizenry. But if you tell me you had a class, that could have been as much as 16 years ago. What qualifications have you done? And most instructors in the NRA will back me up on this. They don't have to qualify either. So, and when we talk about all these other states, when my wife worked really hard to pass Public Act 381 for all law-abiding citizens to have a firearm for protection of themselves and their family with a permit system, the NRA and Mr. Art Tom will back us up on this. They flew in Susie Gracia Hupp, whose parents were tragically killed in Luby's cafeteria in the 1990s. So they flew her in here, along with my wife. I know that because both my wife, Mary Polkowski, and Susie Gracia Hupp were on the Discovery Channel programmed based on that Public Act 381 passing. So she wanted to have her firearm, and she does train. So all we're saying is, we want to make sure, if you have the constitutional right, make sure you have the right equipment and you're trained. And please, we don't want to distract them saying it's any other issue, a woman issue, but everyone has their own particular needs. If you have it in a purse,
Okay.
great, lock it up.
Okay, do you have any additional questions? Okay, Representative Cole.
Thank you, Mr. Chairman. Appreciate it very much. And as a husband of and a father of 3 daughters, I did find some of the comments a little bit jaded against women and their ability to carry and use firearms. As a father that has helped my daughters use their firearms as well. And I said their firearms, they do have firearms as young people that they use for hunting and different purposes and shooting. I want to ask you what the training requirements are for Indiana, and if there's been a rise in issues there with law-abiding citizens and concealed carry in Indiana.
I don't know if there's actually been a rise in that, but I can get that information for you.
Okay,
But
and then
I'm more concerned about Michigan. I know there's over 600,000 concealed carry holders now. What I would ask you, Representative, with all due respect, what will be the increase in concealed carry, constitutional carry if this law passed? And by the way, as for the record, we are against registration. And I know there's one of the bills that says we'd like to eliminate registration, proves no purpose of saving anybody or keeping criminals away from guns. So if you want to add that to the record. And again, we want this law to pass if it is changed to eliminate constitutional carry and to put in the guidelines of increased training and annual qualifications. But no disrespect to your daughters. There are some people that do it. But I would ask you, sir, how many people, and I don't know if you're an instructor or not, if you can inform us, but throughout 22 years of programming, we know that most families do not have the skills and many people come back injured. We see it because we are here giving personal testimony, not to be grilled. But
Yeah.
I can get that information for you, sir.
Thank you. No, I'm not an instructor, other than I've been around guns my entire life, and so has my family. That's something that's very normal in our household, normal in our culture in Northern Michigan, for both personal protection, as I'm not home a lot, and for actual use in things that we like to do. But I want to continue on the questioning here with constitutional carry that's been passed in other states. And believe me, I'm for training. Training is great. I do shoot a considerable amount, and I encourage other people to do that so that they're constantly familiar with their firearm and how to shoot it and how to be accurate. It's important to do that and to think about your target and what's beyond it. That's very important. But in the states that have passed constitutional carry, we have not seen a rise in any of the things that have been mentioned here in this testimony today. It has not happened.
Oh, I would challenge you to say that I don't see anybody at the last hearing or here today, and I mentioned about the Susie Aggressive help. The NRA has actually flew her in. I haven't seen anybody here to give that personal testimony. I haven't seen any data statistics. I provided 70 pages for you as of today's date. I'm willing to look at it and hear your side of the story. But I will mention that because last time it was mentioned about other states. Let's discuss in your packet that I've given everybody here. It says here, Montana Governor Steve Bullock vetoed a bill allowing for carrying of concealed guns without a permit on Thursday. Bullock said in a veto letter that the state sheriffs now may require safety training before granting a concealed carry permit and can deny permits to people struggling with mental illness. He equated the bill to allowing people to drive cars, fly planes, and erect buildings without determining if they are eligible to do so. Let's talk about...
Very different here, sir. Driving cars, that is not a constitutional right.
Well, we're not just talking, we're talking about, you asked me about other states. Let's talk about other states. And it says, while I defend the Second Amendment rights of our citizens, I cannot support an absurd concept that threatens the safety for our communities by not providing for the basic fundamentals of gun safety and mental health. This is what Bullock wrote, and this is in you have copies of this from the Post, and KD7 actually had stated that. So we have here from other states, from what the governors actually stated, and I would ask you, sir, if you could provide me something in writing from those governors.
But I want to get back to this safety and training and what actually happens in the states that pass constitutional carry. And we can look at places like Chicago, some of the most violent places. They have all kinds of gun laws. You don't have lawful gun owners committing those crimes. Lawful gun owners are not going to do that, whether they're open carrying or concealed carrying. Why do we continuously put hoops in front of people that are law-abiding citizens? We have the laws to protect us from the people that are out to commit nefarious deeds, nefarious crimes. Why do we continuously put more hoops in front of law-abiding citizens? It's not solving crime.
With all due respect, you mentioned Illinois. They do have a concealed carry permit system. So they have made it strides, just like we hear in Michigan. And also mention as far as Texas is concerned, because you talked about other states, prediction for the Legislative Budget Board shows a number of license applications and renewals. This is from Texas Open Carry, Constitutional Carry, through the Texas Department of Public Safety. And they stated decline of 90% in the first year under the constitutional carry law. These are the people that are even applying for permits. And this is what the Governor Gary Herbert said about constitutional carry in the state. I wanted to provide something that we haven't heard here today or last week. As a gun owner and concealed firearm permit owner, I understand the value of the permit, both to firearm owners and the public at large. Governor Herbert wrote, as a state, we must exercise extreme care that we do not impose undue burdens on the right to bear arms, but I have yet to receive any credible evidence that Utah's current permit system constitutes the hardship. That was Salt Lake City Governor Herbert. Texas referred to a decline in 90% of people interested in the training, and then it was Salt Lake City Governor Gary Herbert. So you have copies of this. So there's 3 states.
But we're not changing any of the training requirements for CPLs. And CPLs, I personally believe that we're going to see an uptick if we pass constitutional carry. This is my personal opinion, in CPL training, because people are going to want reciprocity. And Michigan has some of the best training and the highest level of reciprocity in the country. I believe it's something in the neighborhood of 40 states. I believe we're going to see actually more training. Your business is going to pick up as people are become more interested in carrying concealed. And that's my personal opinion in that, because once people get comfortable carrying, they're going to want to carry more and cross state lines. Therefore, it's very important that people understand that we're not changing our current CPL system.
Can you, Representative Cole, can you provide any status from that, or anything in written or any print or
That's
any documentation?
just with talking with constituents and their interest in carrying and what they may be interested in doing. So that's where I get a lot of my background from, is
okay.
listening to my
With all due
constituents.
respect, do you have anybody testifying to that from other states right now?
We had some testimony last time around that talked about an increase
We hear from
in
other
that.
states.
So, I don't, right at the moment.
Okay.
Thank you.
And I don't see any other questions, so thank you so much for your time. We have 2 left. Joel Fulton of Freedom Firearms.
Mr. Chair, committee members, first of all, I just want to tell you guys how much I really, really appreciate your being here. I really, really appreciate a second day in 2 weeks of testimony after legislative session and how late you guys are here today. That means a great deal, and I appreciate your consideration, your patience. That's pretty awesome, you guys, so thank you very, very much. Okay. In response to training, and basically what we're looking at here is, first of all, we've heard a lot of comparison of training to police officer training. That's an entirely different mindset. It's an entirely different mindset than military training. We're talking about an offensive mindset at that point. We are talking about people who are charged with going out and protecting us. We heard some testimony early from some folks that said 2 individuals on campus with military training, with their CPLs, with their guns on them, decided not to go out because the police might confuse them. Well, no kidding. That's exactly how we train people in CPL classes. That gun is there to protect you and your immediate vicinity. You are not a police officer. You're not a junior officer. You don't have a badge. Your job is to protect your bubble. So how do more people with guns in public places protect and defend against crime? Because there's going to be more bubbles. Sooner or later, the bad guy runs into a bubble of protection, and then the bad guy doesn't get to be anymore. And it's not that hard for me to hunker down in a room. It's a quick shot right there. Either the guy coming in has a badge and has announced himself, or he's the bad guy. It's an easy decision-making process. It doesn't take nearly as much judgment as what we have to train into our police officers and our military that require more of those judgment decision type things. It's an entirely different mindset. That's why the level of training isn't hundreds of hours. And will those people seek out training? Absolutely. I had phone calls this morning. I had a guy call me up and say, hey, I just got a SIG 9mm through Cabela's. I asked him where he bought his gun. He said, do you guys just offer some training? I'm not as familiar with the firearm as I'd like to be. I just want to be able to go out to the range and maybe be shown how to take it apart and clean it. Absolutely. How much you charge for that? Nothing. Come in and use the range. Do it repeatedly. I'd be happy to have you use my range. People who are concerned about training income and concerned about CPL holders not being mandated to get training, I would submit to you, are worried about income. I'm not worried about that. I'm not worried about my position in the marketplace. I'm very good at advertising. I'm very good at marketing, how good we are, and I'm very good at marketing. I've done 15 years and over 12,000 students. Women, men, minorities, okay, and especially I'm concerned about minorities. I'm concerned about comments like the difference between how we treat people in Escanaba as opposed to Inkster. I'm concerned about population density statements that tell me that the whole reason we've had concealed carry to begin with is due to institutional racism. It's due to the fact that we didn't trust certain minority groups to have guns. And here we are, perpetuating a system of institutional racism instead of granting freedom to all of our citizens. And trusting those citizens that they will go get training in and of their own accord. They will. They will seek it out. Nobody wants to use a power tool or anything capable of causing serious harm to themselves or those that they love without seeking out training. There is no doubt in my mind that the law-abiding will already do that. The criminals? Probably not. They're scared to go into an official place like mine as a criminal and actually utilize it. They don't want to get caught. They already know they're not supposed to have it. There are 22 states in total, 13 states with constitutional carry and 9 states that have no training requirement to begin with. That's 22 states with no training. You don't see any headlines that say, look, because we have no training, we have people shooting each other up and destroying each other. It doesn't happen. As far as guys with guns calls, it's the very reason that we have to have open carry in order to carry on a minimalist budget, quite frankly, people who are living paycheck to paycheck and live in poor neighborhoods like mine. That we get folks with guns calls and then our police have to respond, whereas if they were allowed to put their coat over it, you're not going to have nearly as many of those calls. The police aren't going to have to respond. As far as vetting on the side of the street, it's no different than going in and getting a purchase permit inside the police station. That information is available right there in Lean. Bam, instantaneously. The lady behind the desk can make that decision in less than 5 minutes. An officer can't make that on the side of the street. It's already behavioral based. If your behavior is that he is suspicious and begins to have probable cause, he's going to secure the scene. He'll have plenty of time to vet whether or not you are able to have a firearm. But if you conduct yourself properly on a stop, you turn on your dome light, you put your car in park, you put your hands on the steering wheel with your wrists at 10 and 2, I'm pretty certain that the officer's already going to be confident that he's dealing with a law-abiding citizen, gun or no gun. These things do not change. The way officers interact with citizens on traffic stops will not change. If it's changing, then they've already been complacent. And if they've already been complacent, this has been a bad thing to begin with, because if we've ever let our officers get complacent, complacency is what kills cops. Never should they be allowed to get complacent. In mandatory training, I guess at the end of the day, I would submit to you that it's very similar to poll tests that we used to require in order to allow people to vote. I have the freedom and the right to vote, yes? But why not a little poll test, just to make sure that you're really competent? You have the right to keep and bear arms, but why not a little bit of training mandated by the state so that we have one more way to control you? Freedom's freedom. I would prefer dangerous freedom to peaceful slavery. Thank you.
Thank you. Representative Greimel.
Nice to see you again.
Good seeing you again.
Yeah, and thank you for being here. Thanks for your testimony. I wanted to just touch on one of the things that you emphasized, which I agree with, which is that one of the things that's taught in CPL courses is, again, the appropriate way to proceed if one is in a dangerous situation, when it's appropriate to discharge a firearm. You mentioned that police, unlike private gun owners, are trained to pursue suspects, are trained to protect others, and that in CPL courses often people are instructed that it's only to be used for self-defense and self-protection. And that's a good example of the concerns that I have when it comes to firearms training. It's not about, in terms of firearms training, it's not about law-abiding versus non-law-abiding. We're talking about law-abiding citizens. We're talking about well-intentioned people The goal, it seems to me, of the firearms training is to try to make sure that people use the best judgment possible in a variety of circumstances, and that people conduct themselves in a safe way. And I don't understand why one would be opposed to mandatory training, given that that's its purpose.
Should the state be able to mandate in order for me to be able to exercise a right? It goes down to a basic principle. And that's the end of the day. I am going to submit to you, Representative Greimel, that people will do this of their own accord. I don't need to force people to do the right thing. They will do the right thing on their own. And I trust human nature. And human nature tells me that most people don't go seek a fight. There are very few among us that will go out and seek to confront somebody in the face of human violence. Most people don't like to be in that caustic face of human violence. Our officers are charged with doing it, and we have to select a very select group of those people. I compare most people to sheepdogs, sheeps, and wolves. We know what the wolves are. The wolves are the criminal element that will attack you anyway. The sheep, ordinary everyday people. Most of us fall into that category. Very few are protectors. Very few will seek out the wolf to confront him. They will hunker down. If the wolf finds him, the sheep will often defend themselves if they have teeth. That's what we're doing. We're giving sheep teeth. And they'll defend themselves if they have to, but they don't want to have to. Nobody wants to have to do that. I don't want to have to do that. Most police officers don't want to have to do that. They don't want to be in those situations. And because of that, people aren't seeking that out. They are seeking training to be safe, to be competent, and to be confident should that situation arrive. And they will do that of their own accord. They come into my gun shop all day, every day, seeking out that training.
Well, I think there are lots of people, even most people, who fall into that category. But surely you'll agree that there are some law-abiding citizens who, if it's required, will get the training, but if it's not required, they won't get the training.
And in regard to that, I would also submit to you, there's formal training, right? And there's also informal training. Is it only formal training that will meet any of these requirements? In the end of the day, we're talking about information that can be gleaned on the internet, in videos. In fact, if you were to look at traffic stops, Google Freedom Firearms CPL traffic stop, and you'll see that there's already videos out there. I produced that video at a great cost to myself because I believe that that training needed to be out there, just not for my students, but to be able to review it over and over again. It's a fantastic video and was done in conjunction with the Battle Creek Police Department. Their stipulation was it couldn't be released until they reviewed it and met their expectations. Unfortunately, it didn't meet their expectations. It far exceeded them.
Well,
we were tickled to be able to do that.
In regard to the other question as to how people react based on human nature in different circumstances, I think your observations are accurate when it comes to most folks, but I can think of generally law-abiding individuals, well-intentioned individuals, and we've all seen these kinds of reports. I can think of an instance in my county where a woman was carrying a concealed firearm and a shoplifter was running out of the store, and she opened fire on him. Obviously, probably not something that a CPL course would instruct people to do. I don't know if she had a CPL or not. I don't know if she received the training. It's quite possible that she did. But, and certainly people who receive training don't always follow the training. So I understand that and want to be clear about that phenomenon. But certainly, it seems to me that those kinds of instances are going to be minimized if people receive the training and understand what ought to be done and what ought not to be done. And surely you would agree with that too, that training is a positive.
Absolutely, training is a positive. I don't agree that it necessarily should be mandated. And if those things were happening in that number, and you're talking about one instance out of 605,000 people over the course of 17 years. Or 15 years, I'm sorry, 16 years.
It's one example. There are others that I could share as well. But
the fraction is so infinitesimally small as not to be even statistically significant. If those situations were that big, then you'd see 22 other states that would require some training, and they don't. We're talking about half the United States, and there are 11 million CPL holders nationwide.
Well, my last question, if I may, Mr. Chair, is I've heard you testify today, and I've heard other people say similar things over the course of the past week, that one of the reasons why, maybe a primary reason, I don't want to put words in your mouth, but you've mentioned that fewer people would openly carry if people could carry in a concealed manner without having to pay the onerous fees that you believe associate with CPL. And my question in regard to that is, is it your view that the state could or should, if these bills were to pass, outlaw open carry?
No, not at all. I believe in a balance of open carry and concealed carry. I think concealed carry has its advantages. It certainly gives me the advantage of surprise, and it has the advantage where the bad guy doesn't know I have a firearm. But I think the presence of firearms everywhere restrains evil interference, and they deserve a place of honor with all that is good. That statement was made by George Washington. I certainly think the open carrying of firearms restrains evil interference. It reminds the bad guys when they walk around that good guys are carrying guns, and we probably shouldn't do bad things because there are consequences for attacking people. You want to go commit property crimes? Fantastic. I can replace property. But I can't replace my wife's dignity if she gets raped. And I can't replace life. So I'm okay with a balance of open carry and concealed carry. Absolutely.
Okay, next we have, before we go next, I'm familiar with that case of the Walmart shooter. She actually did have a CPL. She actually did go through the training. So it's just an example that the training that seems to be this panacea to solve all problems, if somebody's slumping and sleeping through the class who doesn't really care, that isn't going to make a difference. Shooting 30 rounds isn't going to make a difference. The training is not the panacea.
I want to be clear that I didn't suggest it was a panacea. I simply said that training reduces those risks, does not eliminate them.
And in that case, I'm sure it was very clearly covered. You can't shoot at fleeing shoplifters at any training in the state, and yet she still did. Representative Sowerby.
Thank you, Mr. Chairman. And to the speaker, thanks for your testimony. Just to clear up a couple things, my comment about population centers was just that densely populated areas tend to promote greater amounts of tensions, of angers, things of that sort. That, I understand the importance of concealed carry, but with a trained society on how they carry those weapons and that they've been trained. As to the comments of the gun range owners, having gone through my own CPL process and appreciating gun ranges and those owners and those teachers, I equate it to school teachers who do it for a living, but also do it for the passion of teaching. And I can speak directly to the prior speakers, Mary and Alan Pulaski, who have their gun range in Clinton Township in my community, a community of 100,000 people. They came before me as I was the treasurer of that community, sat on that board, and came before all of the appropriate departments requesting their range. They went through hoops. But through those hoops, they made it quite clear about what their purpose was, why they were committed to this process of not only owning their own gun range, but publicly the desire and the passion of teaching people the proper way to train. Is it a business? Yes, but it is also a passion. And I do not believe they're any different than a lot of other gun range owners and people who teach, that they are committed to this process, just as to the process that I went through when I received my concealed weapons permit.
If there's no other questions, thank you so much for your time.
Thank you.
And we have finally Art Tom of the National Rifle Association.
Mr. Chairman, members of the committee, I appreciate your time once again this week, as you afforded me last week. Again, I'm here representing the nearly 160,000 members of the Michigan National Rifle Association. And I'd like to start off with a few numbers because you guys have all had some numbers thrown at you today. A series of them not correct, both on the pro side and on the opposition. To start with, one of the speakers, the instructors, talked about they did not see any proof or any overwhelming evidence that training and permits would increase given circumstances of the constitutional carry law. And then it was just mentioned that we have 11 million concealed carry permits in the United States. It's actually currently over 15 million. It was in 2014, it was over 12 million. So that number has substantially increased. There is true more concealed carry permits in existence today than there ever has been. When we talk about the permits and the training increasing and all of that, you look at Wyoming, who in 2002 had 5,136 permits when constitutional carry was enacted. By 2014, that number jumped to 26,627, from 5,000 to over 26,000. When we look at Arizona, in 2010, they had 161,336 active permits. By 2017, that number jumped up to 317,000. That's a substantial increase, an amazing increase, tripled in some of these states that are still requiring training. All the processes that Michigan has are still in a similar place. The reasons that people are getting them there are going to be the reasons that they're getting them here. The NICS bypass is a huge one. If you have a concealed carry permit in the state of Michigan that's active, you don't have to be called into the through the NICS check. You fill out your Form 4473, show them your permit, and the FFL, if they choose, can let you leave with your firearm. That is a huge benefit to concealed carry permit holders. Right now, currently, Michigan honors any state, out-of-state concealed carry permit, and they're recognized by 40. That's massive. That in itself is one of the driving factors in the other states of why permits continue to increase. When we talk about the training and all the, again, the blood running through the streets and all the stuff that we've heard last week and we've heard this week and the dangers to society that it's going to be, when we look to the fact that Michigan, again, recognizes any out-of-state permit, any permit from any state. And we've heard the factual evidence that 22 states currently have absolutely zero training requirement, even more have no live fire requirement, and those issues have not happened in those states. Those issues have not happened or been realized in the state of Michigan. If that was the case, people from Indiana, people from Pennsylvania, people from these other states that have absolutely zero training would be coming in here, and you guys would not be able to barricade the blood that would be running through the streets of Michigan. And it's just not happening. When we talk about vetting the folks and how law enforcement is going to be able to tell whether someone has been is lawfully possessing a firearm, we're not changing any rules to the Terry stop. We're not changing or pulling any of the tools out of their toolbox when it comes to effectively do their job. But what I do challenge each and every one of you lawmakers to question when you think about each and every one of your constituents and your job to protect each and every one of your constituents is that, yes, we support law enforcement. We need them. They're one of the greatest assets that we have to protect our people. And if they say, well, I don't have a reason now to continue to ask questions to this person, my question right back to law enforcement is, why do you have them stopped? Why do you feel that the need to continue this conversation? Do you suspect them of a crime? The Supreme Court has ruled already in several states that simple possession of a firearm does not constitute a crime. But now it should, just having possession of that firearm should make that person potentially unlawful. I don't see where that can we can come to that. Again, disclosure. One, just so everybody's clear, we have been in communications with the Michigan State Police on addressing the disclosure concerns, and under the proposed language, it would move that anyone who is lawfully concealing a firearm would be subjected to disclose as long as they were requested. It wouldn't be upon immediate contact. It would be if the officer requested, then they would be responsible for disclosing. But let me be clear when it comes to disclosure, that duty to inform factually affects no one but a law-abiding gun owner. If you are in illegal possession of a firearm, you are already protected from saying that you are in illegal possession of a firearm. I don't care how many laws that we make saying the contrary. The Fifth Amendment still applies that you do not have to incriminate yourself, and you would indeed be incriminating yourself, and it doesn't matter at which point you're in that conversation with that law enforcement officer. As soon as it comes up, do you have a firearm, or do you possess a weapon, or anything else that you should not possess, you do have the right, under the Fifth Amendment, to keep your mouth shut and not mention it. When we talk about the training, and the former Ypsilanti mayor and doctor talked about the training in undergrad and the training in graduate and her doctorate degree, and it's true, whether it's considered rude or not. If you're bringing up that gun owners, lawful gun owners, are at risk, if plenty of people are coming up here in opposition saying we're at risk from law-abiding citizens, then it's fair. It is indeed fair to point out that behind heart disease and behind cancer, and only behind those two, as the number 3 killer in the United States for quite some time now, at 400,000 in 2014, over 226,000 this year alone, was medical errors. It's fair. If you're going to come up and talk about how bad I am, it is fair. When we talk about training, and I'm sure everybody in the committee here and everybody in this room is well versed in Act 309 of 2006, 780.972, Section 2, that says, generally speaking, that if you are in fear of your life or serious bodily injury, you have the right to use deadly force without retreat. That's the law. It doesn't get much harder than that. I don't understand why we believe that somebody needs days of training and annual recertifications to understand that if you are presented with a circumstance of serious bodily injury or death, and you genuinely fear of serious bodily injury or death of yourself or another person, you have the right to protect your life or the life of another. That's the law. And, you know, whether they're running out of Walmart or where their situation is, there's going to be good sides of that and there's going to be bad sides of that. There's unfortunate situations in everywhere we go. When we talk about the densely populated areas and we talk about, you know, cities like Detroit, cities like Flint, cities like Chicago or LA or New York or Miami, wherever we want to go, and we start discussing about, you know, the heated areas, we're talking about areas that have significant issues. Drugs, gangs, high unemployment, low education, circumstances, social issues that would be extremely difficult to correct. But if we found a way to correct those, crime in general would drop, gun crime included. But that one's a lot harder. It's easier for us to sit around and say, if we just take the guns away, that will stop the crime. And we look at the piece of paper that I again handed you guys that shows, factually shows, and again, this is not from the National Rifle Association, this is from the National Safety Council, and it shows, it proves that while guns and firearm ownership is at an all-time high, gun deaths are at an all-time low. So it's very difficult. I find it very, very difficult for someone to come to me and say more guns equals more crime, more guns equal more deaths. when it's factually not correct. I appreciate your time, and I stand for any questions.
Thank you. Representative Greimel.
Yeah, thank you, and thank you for being here again today. It's nice to see you again. I appreciate your testimony. I just wanted to make one statement, which is that I haven't heard anybody up here as a legislator in this committee suggest that they want to take away anybody's guns.
No, sir.
And I haven't heard anybody up here even suggest that more guns equals more crime, because I don't think most of us up here believe that. The sole question, of course, before this committee is whether those who carry concealed firearms should be required to go through safety training courses and should be required to disclose to law enforcement under certain circumstances that they're carrying concealed firearms. So I hope that none of us, and I've heard some other people who've testified, conflate this issue with other issues. I want to try to focus on exactly what's before us today. Some of us are very supportive, including myself, of the Second Amendment. Some of us, including myself, voted for the shall issue legislation to try to make sure that people who are law-abiding clearly and consistently are granted their right to carry in a concealed manner under the current CPL law. My only question for you is, I heard you indicate that in some states, perhaps many states, that have gone to constitutional carry laws or permitless carry laws, that they have seen an increase in the number of people who have gone through training courses or that have obtained actual permits to carry. We've heard some testimony along those lines last week as well. My only question is, presumably that's a function of the fact that many more people are carrying concealed in general, and I'd be interested to know whether the percentage in those states of those carrying concealed firearms that have gone through training has gone up or gone down, and I'm wondering if you have any data on the percentage of those carrying concealed firearms, whether they've gone through training or not, whether that's gone up or down.
Thank you, Representative. I think it would be difficult to find, a percentage on those numbers simply because if the folks are constitutionally carrying, nobody knows. I do know, in the fact state that, in states like Arizona and Wyoming, permits have increased 3 times over. With that, I mean, there is a significant increase. You can't have a significant increase of that magnitude in permits without, especially after constitutional, this is after constitutional carry was enacted there, without the fact remaining that since the law has passed, more people have sought out training, more people have obtained their permits, again, 3 times over. What the percentage is of the people carrying, I'm not sure. But I can say this, the crime has dropped in those states as well. So if that's the case, then yay, because it's now a safer community, as we suspected it would be.
Well, just to be clear, though, crime has dropped precipitously across the country in virtually every state over the course of the past 20 years, not just those who have gone to permitless carry, but also the many states that have not gone to permitless carry. So I'd be careful to draw causation conclusions from correlation.
Sure, and I understand your statement, but with the testimony that we've heard today and the testimony that we heard last week, it's very clear from those who testified that they believe that the exact opposite is going to happen. And the proof is in those states that that's not happened. In fact, the opposite has happened. Crime has continued to drop in those states even after the passage of constitutional carry.
Representative Cole.
Thank you, Mr. Chair, and thank you for your testimony. Really appreciate that. At the risk of complicating the issue, does Michigan law obligate disclosure for out-of-state CPLs when interacting with law enforcement officers?
Not the way that I understand it, no. And through that, it's because of the verbiage licensed under this act, which, as a West Virginia resident, and licensed to carry a concealed firearm by the state of West Virginia, under the language in the Michigan law, I'm not obligated to disclose to a law enforcement officer that I'm carrying a firearm.
Yeah, and thank you very much for the clarification of that. And I really appreciate your comments, especially in regards to my colleague Rep. Greimel, about the increase in CPLs with constitutional carry being instituted into these states, and the fact that more guns, more CPLs, more constitutional carry, yet we see a decrease in violent gun crimes, especially with law-abiding citizens. So I really appreciate that testimony very much. Thank you. Thank you, Mr. Chair.
Thank you, Representative.
Any other questions from the committee? If not, thank you very much for your testimony. And we have in opposition but not wishing to speak, Martha and Rick O'Million with Moms Demand Action, and also Melinda Dickinson with Moms Demand Action. We have in opposition, not wanting to speak, Kim Worthy of the Wayne County Prosecutor's Office, DJ Hickson of the Muskegon County Prosecutor's Office, Linda Bondage of Michigan Coalition to Prevent Gun Violence. And
Mr. Chair, just a point of order. I hate to interrupt, but if you could identify which of these cards are in opposition versus in support, that would be great. Or all of these in opposition?
All those were in opposition. Okay. Yeah, I'm sorry. Not wishing to speak opposed to the bill with the Michigan Coalition to Prevent Gun Violence is Linda Brondage and Linda Veralanen. Again, in opposition is Nicole Bandon, representing herself. Supporting the bill is Gregory O'Neill, representing himself. Supporting the bill is Wayne Groth of the Calhoun City Gun Owners Association. Opposing the bill, not wishing to speak, is Ann Marston. Opposing the bill, not wishing to speak, is Janet Lexius. And supporting the bill, not wishing to speak, is Cammie Pendleton of the Michigan Judges Association. And opposing the bill, not wishing to speak, is Kathy Hageman of the Michigan Coalition to End Domestic and Sexual Violence. Now we need to excuse Representative Robinson. Need a motion. Representative Greimel, so ordered without objection. And there being no further business before the committee will stand adjourned.